Lordship. My Lord, I beg to mention item number 18 and 19, and 1920, sorry. 1920. Yes. Your Lordship, may this be posted on 8 May. The parties have consented. I'm for the respondent, private respondent. Respondent. R. Iralu. Your Lordship. Oblige.
Maybe please to mention item 3, Your Lordship. This item 3 is wrongly listed, Your Lordship. It is supposed to be listed on 22/5. So maybe inadvertently it is listed today. Otherwise, it is supposed to be it come up on 22/5. Livika, Your Lordship, Government Advocate, Your Lordship. Yes, Your Lordship.
Obliged, Lordship. Lordship, I am for the petitioner. Laknepam, Lordship. Obliged.
May I please, Your Lordship. My Lord, allow me to move one unlisted and distributed bill, my Lord, as a last item or 8.2, my Lord. My Lord. Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item 26. Yes. Your Lordship, I pray that the matter be listed after 2 weeks.
No, Your Lordship.
Yes, Your Lordship. Sigmo. Yes, Your Lordship. Your Lordship, similar order for item number 27. Much, Your Lordship.
Your Lordship, I beg to mention hearing item number 22. Here, Your Lordship, state has filed a writ appeal bearing number 4 of 2025. So this writ petition will depend on the outcome of the writ appeal. So if this may be listed after disposal of writ appeal number 4 of 25.
Lordship, similar petition has been disposed of by the Honorable Supreme Court, Lordship. Similar nature, besides the appointment date and the retirement date. It's the same case. A work-charge employee, he was appointed on fixed pay, he retired on fixed pay. So a similar case has been already disposed of by the Honorable Supreme Court.
Yes, Your Lordship, it was recently filed.
Lordship.
Tomorrow it's coming up on division bench. Writ appeal number 4 of 25. AIME.
Lordship, if I'm not wrong, this writ appeal was filed after the order passed by the Honorable Supreme Court. Maybe okay for you, Victor. Chiang Mai.
Please, Lordship, please allow me to mention hearing item 25 on behalf of Sor Ali Sheikh, the counsel for the petitioner. He is all-session lawyer, all-session counsel. So on this instruction, I pray the matter be listed on 22nd May.
Lordship. No matter.
Item 25. Yes, my lord.
In Angami, my lord. Lordship. Lordship. Deeply obliged, my lord.
Hello, please.
May I please, Your Lordship, I beg to mention item number 6, that Lordship, this matter has been fixed for admission hearing, but on the later date, we are asked to file the counter affidavit, but we're not filing the counter affidavit, so may this matter be listed after 1 week? Yes, Lordship. Yes, Lordship. Much obliged.
May I please, your Lordship, I beg to mention item number 5. I'm for respondent number 5, Lordship. Lordship, kindly allow me 1 week time to file additional affidavit. Okay.
May I please, your Lordship, I'd like to mention item number 28 hearing. 28. Lordship, let the matter come up after 3 weeks. Yes, Lordship.
May I please, Your Lordship, I beg to mention item 10. Here, we are yet to receive any instruction from the client, so kindly grant us 3 weeks' time to file the contract.
May I please, your Lordship? Lordship, I beg to mention item number 17, hearing item, Lordship. 17, Lordship, hearing item. If this matter can come up after a week, Lordship.
Yes, Your Lordship.
Lordship, I'm for the 18, Lordship. Here I'm the petitioner in item number 18, Lordship. These are analogous matter. No, Lordship. Respondent number 4. Lordship.
For the state respondents, Lordship.
No objections, Your Lordship.
For a week, Lordship.
Your Lordship, if the matter may be fixed for May 18.
Lordship. Yes, John.
Um, 13 May, Your Lordship, 13. Yes, Your Lordship.
Much obliged.
Lordship, I have similar prayer for item 23, Lordship. On behalf of my senior Lordship, MD Im Song Edition Age, if.
Lordship, I'm appearing on behalf of the counsel for the petitioner, Lordship. Lordship, if this matter can be listed on 29 of this month, since the counsel for the petitioner is outstation advocate. Sukajish, Lordship. On behalf of counsel for the petitioner. Ihitochishi, Lordship. Blessed Lordship.
May I please, Your Lordship? I beg to mention item number 29. If this matter can be listed after 3 weeks, Lordship. Yes, Lordship, I'm for the petitioner.
No, ma'am.
R. Mary.
Deeply obliged.
For motion, item number 1.
May I bless your lordship? This is a petition for appointment on compassionate ground. So my father was working as a composer, and he expired on 9/8/2022. Thereafter, I have submitted the application for my appointment, but no action was taken, no reply was given. So I've submitted a representation on 14/2/2025, but no reply was given. So I'm filing this petition. Yes, your lordship. Mua chung là.
S. Chang. Lordship. Lordship, 4 weeks. Lordship.
For motion, item number 2.
May I please, your lordship? Yes, lordship, through this petition, I am challenging clause 3A of the notification dated 5th of March 2018, as well as the appointment of private respondent number 7 for seeking appointment to grade 4 post on the basis of land ownership, lordship. Lordship, the brief fact of the case is that in the year 1994, an agreement was entered into between the district administration Voka and my grandfather, whereby a plot of land along with the residential quarter belonging to my grandfather was acquired by the district administration for a sum of rupees 3 lakhs for the purpose of establishing the existing dispensary at IDBong, which is under the Chief Medical Office Voka, with a written agreement, along with the stipulation therein that as and when any grade 4 post arises, then the first preference would be given to the landowner lordship. Now in the year 2022, post became vacant due to the demise of one Sri late Simon Antan, and consequently I applied for the said post on the basis of land ownership. And the private respondent number 7 herein also applied for the post. However, lordship, the private respondent number 7 was appointed by the state. Therefore, aggrieved lordship, I approached this honorable court challenging the appointment of private respondent number 7 by filing a writ petition, which was writ petition number 78 of 2024, lordship. However, during the course of hearing, it was observed that my petition was barred by clause 3 of the notification dated 5th March 2018. It's at page 80, lordship. 80, Lordship. Yes. Yes, Lordship. So the clause 3A of the notification. So Lordship, this notification is a policy with regard to appointment of grateful post on the basis of land ownership. And now Lordship, this clause 3A states that in other cases prior to 26/7/2005 and subsequent to setting up of administrative and block headquarters on freely donated land, where a specific written agreement exists providing for employment to the landowner, the claim of landowner for employment should be settled in terms of such agreement. So Lordship, since this clause 3A, no, Lordship, because my land does not fall under the criteria of the freely donated land, which is under clause 3A. Because it was the land of my grandfather was part paid, however, with a written agreement and a condition, Lordship. No, Lordship. That's why since this 3A part, the petition which I filed before this honorable court, I requested this honorable court to withdraw that petition with the liberty to file afresh, and the liberty was granted to me by order 4th of April 2025, Lordship.
No. Let the notice call. I am representing your lordship 1 to 6 state respondents. Respondent number 7 is a private respondent.
Lordship ini.
By virtue of
Yes, Lordship.
more ancient, your lordship. More ancient.
Much obliged, Lordship.
For admission, item number 4.
May I please, your lordship? Your lordship. Dr. Ankit Todi.
With the lordship's permission, I'd like to submit virtually, but perhaps lordship's is not audible. I've already raised up with the registry.
Lordship is not present now, but he just contacted him. He's on his way, Lordship. It can be taken up after some time, Lordship.
Lordship is not audible completely.
How audible?
Yes, Lordship.
Yes. You want to argue this matter on merit virtually?
Yes, Lordship.
That will not be possible. But since is a outstation council, the respondents council,
No, he's a station council.
why is he not in the court?
Lordship.
Then we'll post it on some other day. Dr. A. Todi, learned counsel for the writ petition is present to VC. However, none has appeared for the respondents in the matter is filed. Since the writ petition has been listed for admission hearing today, the matter cannot be taken up in the absence of the respondents' counsel. As such, let this writ petition be listed again for admission hearing after 2 weeks, fixed date. Interim order passed earlier to continue till
Much obliged.
May I please, Your Lordship. Lordship, I'm for respondent number 5. Lordship, I kindly grant me for 1 week time to file additional affidavit.
yes. Sister City Government and Senior Council is present for the writ petition. Miss,
Nagalish, Your Lordship.
I forgot some of the names, so I have to. bear
No
with
problem,
me.
Your Lordship.
That's why I should come here. more
Frequently.
So and so, pardon me if there is any mistake in the names. huh?
No problem, Your Lordship.
If I sit for 2-3 days, I'll get all the names. So and so, learned government advocate for the state of Assam, Nagaland prays for 2 weeks,
1 week, Lordship.
1 week.
Private respondent number 5, Lordship, I'm for.
You're for private respondent?
Yes, Lordship.
So and so, learned council appearing for the private respondent number 5. 6, further 1 week's time to file counter affidavit. Full stop. Miss, you are for?
I'm for the state, Lordship.
Your name, please?
Bichano.
Miss, please help him with the names. Huh? Please help. Miss so-and-so, learned government advocate, state of Nagaland is present for respondent numbers 1 to 4. Since the prayer made by the respondent number, council for the respondent number 5 is not opposed, same stands allowed. Let this matter be listed again after 10 days for admission. In the meantime, counter affidavit be positively filed by the respondent number 5.
Much obliged.
Petition item number 6.
May I please, Your Lordship. Lordship, as I've mentioned earlier, this matter has been fixed for admission hearing, but on a later date, on 21 March 2025, we are asked to file counter affidavit again. But since we're not filing the counter affidavit, may this matter be listed for admission hearing after 1 week.
Affidavit in reply, not counter affidavit. You are the petitioner.
Yes, Lordship.
So you want to file affidavit in reply.
Yes, Lordship.
Any objection? How much time you want?
1 week time.
We'll give you 2 weeks. Give her 2 weeks on the prayer of Miss
Chivuvela.
Chivuvela, learned counsel for the petitioner. This matter stands adjourned for 2 weeks so as to enable her to file affidavit in reply. Miss, who is appearing for the Miss
AIME for state respondent, respondent 1 to 3.
Miss AIME, learned government advocate, state of Nagaland is present on behalf of respondent numbers 1 to 3 and Miss,
Respondent number 4, respondent number 4, Ayala Engine.
your name please?
Ayala Engine.
ILMG, learned counsel for respondent number 4 and do not have any objection to the prayer of the petitioner's counsel. List the matter accordingly.
Your Lordship, his state is here to file affidavit, so kindly grant me 3 weeks time. I'm here to receive the parawise comments.
No objection, Your Lordship.
On the request of Miss AIME, learned government advocate Assam, for state of Nagaland, this matter stands adjourned for further 4 weeks so as to enable her to file counter affidavit. Miss
Conley.
Miss Connie, learned counsel for the petitioner is present and does not have any objection to the said prayer. List accordingly. Item number? Yes.
Yeah, please, your lordship.
Please, 1 minute, please make a note of the name of the councils. If he has problem, you have to give it. Huh? Yes.
Lordship, I beg to mention on behalf of my colleague, lordship, if 2 weeks' time is granted to me, I've sent for vetting, lordship.
The learned government advocate state of Nagaland prays for further 2 weeks' time to file counter affidavit. The prayer is not opposed by Mr. Takatichu, learned counsel for the petitioner, hence the same stance alone. This case again after 3 weeks. None to assert already, Takatichu. Yes.
Obliged, lordship.
Item number 9.
Lordship, I have similar prayer here, lordship, but here I'm yet to receive instructions, lordship. So if 3 weeks' time is granted to me, lordship.
Ms. So-and-so, learned government advocate for the state of Nagaland submits that she is yet to receive instructions and therefore further 2 weeks' time be granted for obtaining instruction and filing affidavit. The prayer is not opposed by Ms. Your name, please.
Sigmo.
Could you repeat your name, please?
Sigmo.
Sekmo. Learned counsel for the petitioner, hence the same stands alone. Let the matter be listed again after 3 weeks.
Obliged, lordship.
Obliged, lordship.
May I please, your lordship?
Yes.
And for the respondent number 6, kindly grant us 3 weeks time to file the affidavit in opposition.
Mr. your
Autumn
name?
Jamir.
Mr. So-and-so, learned counsel for the respondent number 6, prays for and is granted further 2 weeks' time to obtain instruction and file affidavit. Miss
Bichano for the state.
So-and-so is present on behalf of the state respondent. Mr.
Tushitumchen.
Tusi Komji, learned counsel for the petitioner is present. First line. And in view of the above, let the matter be listed again after 3 weeks.
Much.
My pleasure, lordship. Lordship, here I made a file the affidavit, so if 3 weeks' time will be kindly granted to me, lordship.
Mr.
Autumn Jamir for the petitioner.
Learned counsel is present for the petitioner. On the request of Miss
Bichano for the state.
each other, learned counsel for the state of Nagaland. 3 weeks further time is granted to file counter affidavit. Let the matter be listed.
I oblige.
Oblige.
My pleasure, lordship. On behalf of my colleagues, Achungli, he has already filed the affidavit, so if this matter will come up after 2 weeks, lordship.
You want to file reply?
No, I haven't. It seems he has filed that, but I haven't received the copy of the affidavit in reply.
Yeah.
However, this matter could have been disposed of if reply was there. However, if he's not there, then it may be listed after 2 weeks. I have no objection. I've not received a copy. That's the only reason.
Mr. Your name, please?
Arun Long, Your Lordship.
So, Nam to Salem. Mr.
Arun Long, Your Lordship.
R.N. Long.
Yes,
learned
Lordship.
counsel for the petitioner is present and submits that no copy of the counter affidavit filed on behalf of respondent numbers 1 to 3 has been served upon him till date.
Yes, Lordship.
First up, the learned government advocate for the state of Nagaland assures this court that within 3 days from today, copy of the counter affidavit will be served upon the petitioner's counsel. In view of the above, list this case again after 2 weeks in the admission column.
Much pleasure.
Yeah, please, lordship. Lordship, I beg to mention on behalf of Im Song, additional AG, lordship. If 3 weeks' time may be granted to file affidavit in opposition, lordship. I'm yet to file, lordship.
A prayer for adjournment has been made on behalf of Mr. Im Song, learned additional advocate general for the state of Nagaland, seeking 2 weeks further time to file counter affidavit. Since the prayer is not opposed by Ms. Only Buchab,
Yes, Your Lordship.
learned counsel for the petitioner, same stands allowed. Let the matter be listed accordingly. Agor order to you will get both their names.
Much obliged.
Much obliged.
May I please, Your Lordship. Lordship, my affidavit in reply is under preparation, so kindly grant me 2 more weeks, Lordship.
You are Miss?
Mika HI, Your Lordship.
My lord, I filed my affidavit on behalf of the state respondents.
You are Mr.
LD Sankta,
Mr. LD Santam,
additional AG.
learned additional AG,
Yes.
appearing for the state of Nagaland, submits that he has already filed counter affidavit on
Yes.
behalf of the state
Yes, ma'am.
in both these state petitions.
ma'am.
Full stop. Responding to the above, Miss
Mika HI, Your Lordship. Mika,
Mika
Lordship.
HIA, Mika HIA, cause list of top. Appearing for the writ petitioner seeks 2 weeks time to obtain instruction and file rejoinder affidavit if so required. In view of the above, these matters, admission hearing of these matters stand postponed by 3 weeks so as to enable the petitioner's counsel to file rejoinder affidavit.
Much obliged, Lordship.
Missed accordingly.
May it please your lordship. Lordship, as per the this honorable court's order dated 18/3/2025, lordship, the petitioner has served justice service to the respondent number 5 on 25/3/2025. Personally to the respondent number 5, lordship. So lordship, notice is deemed served.
No, have you filed affidavit?
Lordship, yes, this morning I filed the affidavit in this regard, lordship.
So the affidavit is not on record, then we'll have it day after tomorrow along with the affidavit. We'll
Okay,
post it, because without the affidavit, we
Okay.
cannot.
Okay, lordship.
Your name, please?
W. Marshall, lordship.
Mr. W. Martin, learned counsel for the petitioner, submits that in terms of the order dated 18/3/2025 passed by this court, thus the service of notice has been completed on respondent number 5, whereafter an affidavit has been filed this morning, that is give the date. Full stop. However, the affidavit is not on record. Stop. Registry to thereof for list this matter for orders again day after tomorrow on date to devote Thursday by taking the affidavit filed by the petitioner's counsel for necessary orders.
Much obliged.
May I please, Lordship.
Yes, please.
Lordship, the issue involved here is a seniority disputes in the ring of forest ranger. In your initial point of entry. Lordship, the.
Okay, who is appear, any private respondent here?
Yes, Lordship.
You are for the private respondent and for the state?
Lordship.
Okay. All right.
Yes, Lordship. Lordship, may kindly come to page number 127. 126.
So first, give me the facts.
Lordship, the facts is like this. Lordship, the. Lordship, may kindly come to page number 26. This is a recommendation made by the Nagaland Public Service Commission. This is a notification of 2011. Page number 26
Page number 26 of the writ petition.
of the writ petition. Lordship. This is a notification of 25th July 2011. Lordship, the present writ petition is concerned with the forest ranger, so the relevant portion is page number 29. Should we kindly come to page number 29.
Page number?
29. Relevant portion. Lordship.
Yes.
Serial number 14, Lordship.
Yes.
4 posts of forest rangers. Lordship, here, four candidates were recommended by the Nagaland Public Service Commission. And Lordship, all of these four candidates,
Hmm.
Lordship, Sri Kuza Churi,
Hmm.
he was recommended from the general category. That is not in dispute. And the serial number second, I Long Pom, he is from the Pequot tribe community. And serial number 13-4, they are the reserve category from the reserve category of forest graduate. So serial number 2, 3, and 4, they are from the reserve category. Serial number 1, he is from the general category.
All right.
Worship, that fact is not in dispute.
Hmm.
Worship, in compliance to the recommendation, Worship, become the page number 34.
Yes.
This is the appointment order issued on the basis of the state recommendation. The four candidates were appointed. My name is not included here. Worship.
What is the date of the appointment order?
25th October 2011. Worship.
Yes.
Worship. Subsequently, Worship, may come the page number.
Just a minute. Your name is not there.
My name is not your Worship. My name will come on later on. Worship. Worship, may come the page number 37.
So these four candidates who were selected have been appointed as forest rangers.
Forest rangers. Worship.
All right.
Yes.
Then
Worship, may come the page number 37.
yes.
Your Worship, this is a letter dated 31/12. No, Worship.
Letter dated 31/12/2011.
2011, Worship. Yes, Worship. Your Worship, this is a resignation letter tendered by Koza Churi, the candidate who has been selected from the general category.
Yes.
Notification was issued, selection of candidate was declared on 25th July 2011. And this was, the resignation was tendered on 31st December 2011. That is within a period of 6 months. Worship, the limitation period is also very important in this case. Accordingly, Your Worship, the conservator of forest, he forwarded this resignation to the state government by next annexures 38.
Yes.
Worship, we come again page number 39. This is a release order. By this order, Koza Churi was released from service. This is 24/2/2012. And Worship, become the page number 40.
What is the date of this order? 24.
Worship, this is 24/2/2012.
Yes.
Worship, become the page number 40. From here, my issue will start.
Page 40.
Page 40, Worship. This is our letter dated 6 March 2012.
Yes.
The state respondent, they have requested the Nagaland Public Service Commission to recommend the next candidate. The first, may I read this one? I'm directed to enclose here with the release order of Sri Koza Churi, Forest Ranger, resign, and to request you to recommend the first candidate in the waiting list maintained by your office to fill the post of Forest Ranger recently vacated by Sri Koza so-and-so. Accordingly, Your Worship, by page number 41, the Nagaland Public Service Commission has recommended many.
Yes.
Yes, Lordship. Lordship, we come to the next page. The offer of appointment was made on 13 July 2012. The next page, page number 42. The offer was made within the period of 1 year from the date of recommendation. And by next annexure, page number 43. I was appointed as recommended by the Nagaland Public Service Commission on 30th August 2012. And Lordship, we come to page number 44.
1 minute. What is page 43?
Lordship, page 43. This is the appointment order. Page number 42, this is just an offer. Whether I should accept or not. Offer was made within the period of 1 year.
Yes.
And by next annexure, page number 43. This is my appointment order. And Lordship, we come to page number 44. Lordship, prior to my recommendation, I was serving as assistant jailer in the Department of Prison. So after I accepted the offer of the post of forest ranger, I was released by this notification. I was released from the forest ranger in this terms of condition was issued by the respondent department. Lordship, the main issue which is involving the prison rate petition. Lordship will start from this page number 45.
Yes.
Lordship, this is a letter dated 4th October 2012. This is a letter written by the state government to the Nagaland Public Service Commission, seeking clarification for maintaining the seniority in respect of the direct recruit of the 2011 batch. Which may read, I'm directed to refer to your letter number so and so, and to seek clarification of the seniority status in respect of Sri so and so, that is Sri Mumbai is the present petitioner, forest ranger, versus the other 3 candidates who were selected through the same examination in the same year.
So what is your claim here? You want seniority above the 3?
Lordship, after this,
Your claim, I'm asking.
my claim is this. My claim is we are the we're the we're selected out of the same selection, out of the same year. Our seniority should be maintained on the basis of the merit list maintained by the Nagaland Public Service Commission.
No, but you joined later because the other candidate resigned.
Other candidates.
You can't get seniority over these 3 who joined earlier than you. You can argue as long as you want.
No, this is a judgment passed by the Apex Court in the Bihar Munsif case. It's a similar fix.
Let us
That is reported in 1998, volume 5 ACC 246. I have submitted a list of books.
Yes. Where is the book?
List of books.
Okay, by the time the book comes, you
Yes,
can,
Lordship,
on the facts, you
we'll
can-
complete the facts, Lordship.
Yes. Then what happens?
Yes, Lordship. Lordship, we come to page number 45.
Yes.
Lordship, in compliance with this letter, the Nagaland Public Service Commission, they have furnished a select list of the 2011 page, to page number 47. This is the merit list forwarded by the Nagaland Public Service Commission. And Lordship, my name figured as serial number 1, Sri Mumbai. And the other three, serial number 2, 3, and 4, they are the present private respondent in the present case. Lordship, after the subsequent development thereafter is in the year 2014, a memorandum was issued. This is a tentative seniority list, page number 48.
Page number 48.
48, Lordship. Lordship, may kindly come to page number 50, from serial number 28, it starts.
Page number?
Page number 50. My seniority, my placement is at serial number 28. Private respondent number, private respondent there at serial number 29, 30, and 31. I Long Bom, Bon Sini King, and M Kong Snap. Here are present private respondent. Lordship, against this tentative seniority list, the present private respondent number, present private respondent, they have submitted their respective representation, which is enclosed at page number 50, 51, 52, and 53.
Hmm. 50,
50, 51, 52, and 53, Lordship.
it can't be. 50 is the seniority.
Yes, Lordship, their representation starts from page number 51. Lordship, in your representation, the grievance was against serial number 25, 26, 27, and 28 in the tentative seniority list. Since 25, 26, and 27, there are also the promotees of the same selection of the same year in the cadre of forest ranger. So their prayer was, since they are the direct recruit, the promotees should be pleased senior to them. That was your condition. In this year, in the year 2011, 7 posts of forest ranger was filled up, 4 by direct recruitment and 3 by promotees. So they have, in their representation, they have made their grievance against respondent placement of serial number 25, 26, and 27, and 28. You did this me. Lordship, the other is not so important, but Lordship, they filed a writ petition. Since their demand was not considered, they filed a writ petition. They filed the petition number 232. The writ petition, Lordship, I have next from page number 59. But Lordship, what was their contention against me in the writ petition? Lordship, may come to page number 70, para 12. This is a specific statement which they have referred to me.
Writ petition filed by this private respondent.
3 private respondents. And Lordship, in compliance with the direction passed by this honorable court in this writ petition, the present final seniority was issued.
And where is the order?
Lordship, the order, before I come to the order, Lordship, this is very important, para 12, page 70.
Page?
Page 70. Lordship, I'm not reading the whole paragraph, but Lordship, may come to the sub-para in para 12.
Yes.
Be it mentioned that although the petitioner submitted representations against serial number 28, that is me, of the imperial seniority list, that is so-and-so, on the proper advice of the council, the petitioners are not pressing us against the serial number 28 of the seniority list. So this was your specific statement that on the basis of the advice given by the council, you are not pressing the seniority position against me. After this honorable court passed a favorable order in your favor in the writ petition, which was upheld by the division bench, he submitted a representation against my placement.
No, let us see what is the order in the.
Yes, Lordship. Lordship, the order is at page number 77. If the findings in the decision of this honorable court, it starts from part 11. Page 87. Lordship.
Just a minute. The operative part is page 14.
Lordship, yes,
The para 14, page
Yes,
88.
Lordship, yes, Lordship.
So the, the seniority has been interfered with.
The
And,
seniority of the three promotees, that has been the seniority position of the three promotees,
Hmm.
that's been interfered by this honorable court. I was not made a party in this repetition.
Okay, which para you wanted to show? Para?
Lordship, the findings in the decision starts from para 11, but the operative portion is para 13 and 14.
All right, let us read para 13 and 14.
Yes, Lordship. On the third condition of the respondent, petitioners were selected and appointed to reserve posts. Lordship, I'm reading from there, para 13. On the third condition of the respondent, that is, petitioners were selected and appointed to reserve posts. As such, they were placed lower in seniority list. This court is of the opinion that the same is unreasonable and totally against the reservation policy. Reservation of posts in services are made to ensure adequate representation in such posts and service from backward communities. It can never be used to determine seniority, especially in situations like the present case. Paragraph 14. In view of the reason given above, the writ petition is allowed in the impugned notification dated so and so, memorandum dated so and so, and letter dated so and so at the C of the writ petition, respectively, are quashed and set aside. According, the state respondents are directed to prepare and issue a fresh seniority list, keeping in view the dicta of various judgment of the Honorable Supreme Court that the person's seniority has to be counted only from the day he is born in the gather. Your Lordship, by taking the principle, a person's seniority has to be counted only from the day he is born in the gather. My seniority position was affected. Lordship, that is the issue. And Lordship,
Then any writ appeal preferred against this judgment?
against this, they have preferred a writ appeal.
Who preferred?
The private respondent. No, the three promotees.
Ah,
The three promotees, they prefer a writ appeal against this. The writ appeal was also dismissed by upholding the decision passed by the nursing judge.
okay, then what is the, where is the order? Writ appeal order?
Yes.
Okay. Page,
You should come to page number 96. The finding of the Honorable Division Bench is page number, para 15.
Para?
Para 15, the findings, Lordship. The writ appeal has been dismissed,
Yes.
Lordship. In compliance to the direction passed by the learner single bench as well as the division bench, the respondent department yet issued a memorandum, which is at page number 108.
No, just a minute. What is there in para 15?
Para 15, Lordship, this is the decision of the division bench, Lordship, Honorable Division Bench, dismissing the writ appeal, upholding the decision passed by the learner single judge. Yes, Lordship. Lordship, may kindly come to page number 108. This is a memorandum which was issued in compliance to the direction passed by the learner single bench as well as the division bench. Lordship, here it's mentioned.
Yes.
Lordship, the first three line is important in this memorandum. In continuation of this department memorandum of event number in compliance to the Honorable High Court's judgment in order dated 27/5/2019, that is passing by the single bench, and direction to abide by the judgment in order to Lordship, here they have issued this tentative seniority release in compliance to the direction passed by this Honorable Court. Lordship, in this tentative seniority release, Lordship, may kindly come to the page number 109, the placement.
Yes. Yes, please.
Lordship, may come to mine from the top, serial number 6. Mua Mongba, that is the petitioner.
Serial number 6.
Yeah, Lordship. Mua Mongba, Lordship, got it?
Hmm.
Ai Long Bom, Pusni King, and M Kung Senap. Here are the private respondent. In compliance with the direction passed by this Honorable Court also, my seniority was placed above them by taking the principle direct recruit of the same selection should be determined on the basis of the merit list.
But all four of you have been given seniority above the promoting officers.
Yes, Lordship.
So this much, this is okay.
Up to this is okay.
Then what has happened?
Yes, Lordship. Lordship, may come to page number 113. This is a representation which they have submitted. Lordship, just to recollect your Lordship memory. In the writ petition, they have taken a standard at para 12. As per the proper advice given by the council, they are not.
That's how I have understood.
Yes, Lordship.
You are saying that the first writ petition, when it was filed, it was not directed against your client.
No.
It was directed against the promoting
Only the
officer.
three promotees.
But the learned single judge, in a way, digressed from the main issue and upheld that date of joining or born in the cadre.
Should be the criteria.
Yeah, so if that is to be implemented, then your client becomes junior to the private respondents because they were born in the cadre prior to you.
Yes, Lordship.
But your case is that regardless of whenever I am born in the cadre, because my appointment is against that vacancy meant for general category. So even if I have come in later, still I will be senior to them.
Since seniority has to be determined on the basis of the merit list. On the
You are
basis of-
right. But if you join together, then only. not in these circumstances.
Lordship, yes, Lordship, I'll satisfy the Lordship on that too.
Please, please. Otherwise, the learned single judge might be wrong in diverting the issue. But the law is.
Law is
the person
different.
is correct.
Law is different.
That's correct.
Lordship, law is different.
Your argument will be correct if it is the same date of joining.
Yes, Lordship.
But if you come in after 6 months, then you cannot hold word into the first.
Lordship, here in the this Bihar Monsif case, Lordship, the same issue, same facts situation involved here.
We'll see that judgment.
Yes, Lordship. Lordship, before I come to the judgment, Lordship,
Yes.
can you allow me to complete the facts? It's not just a few annexures. Lordship, page number 113. This is a 113.
Yes.
This is a representation submitted by the present private respondent requesting the authority to rectify my seniority position. Lordship, thereafter, Lordship, the department sought the clearance from the Nagaland Public Service Commission also, and Nagaland Public Service Commission also reaffirmed their earlier opinion, which saying that select list has to be determined on the basis of the merit list. That is in page number 114.
What is 113?
113 is a representation submitted by the present private respondent against me, against my placement in the tentative seniority list.
Yes.
Yes, Lordship. And Lordship, department, they have sought the clarification from the Nagaland Public Service Commission. And the reply given by the Nagaland Public Service Commission is page number 114. Here they have reaffirmed their earlier view, which they have submitted earlier. They have referred to the letter dated 25th July 2011. And here also they have, in the page number 115, they have sent the same select list. Page number 115. Combined technical examination, services examination of 2010. Here,
Yes.
Koza Churi, the person who has resigned, he's at serial number 1. My name is at serial number 2. This is as per the marks secured by me as well as the private respondent. They have furnished a select list. So there's no dispute that in the as per the select list, I'm ahead of them. And now, Lordship, department, they have again, thereafter they have issued a candidate seniority list. From here, I make brief, page number 116. Here again, they have referred to the judgment in order passed by this honorable court. But here in this tentative seniority list of 23rd August 2021. Now I am placed below the private respondent. Our placement is at page number 117, Lordship. From here, the issue starts.
Yes.
Yes, Lordship. Lordship, the private respondent, they are placed at serial number 1, 2, and 3. I am placed at serial number 4. So petitioner, he has submitted a representation. That is at page number 120. From 120 to 125. This was submitted on 26/8/2021. And Your Worship, we come to page number 126. This is the immune seniority list. I'm telling you.
126.
126. This is the forwarding letter. Page 127. Annexure X1. Worship. This is an immune final seniority list. Worship, this is also in compliance of the Honorable Court judgment and order this and so and so. This was issued in compliance with the direction passed by this Honorable Court. So my condition here is, I was not the party in this writ petition. I was not with the party in the writ petition, but the private respondent. Also, the principle laid down in this judgment passed by this Honorable Court is not applicable to me. Since the principle laid down in these cases, an issue between the direct recruiting bodies. Whereas the present issue is an issue between the direct recruit of the same selection.
Mr. You please try to understand one thing. First of all, I don't think your argument is correct. But even if it was correct, then also the single bench cannot do anything. You should have filed a review in that writ appellate order. The division bench has issued a direction telling them that you should be placed below them. They have complied with it, and you expect the single judge to now set aside this. Question doesn't arise. Question doesn't arise.
No,
Even if your argument was right, then also it is not possible.
No, single bench is not in
I am telling you so that you get a chance to respond, nothing else. The division bench, you may not be a party there, but then you should have gone and filed a review saying that first hear me, modify your judgment. How can the single judge go against the division bench judgment? How can the government go against the division bench judgment? It's not possible.
The single bench also has not passed any adverse order against me. It was also finding that seniority has to be determined on the date from the born in the getter.
Nothing can be done. You have to get a modification of that division bench judgment or go to Supreme Court. As a single judge, nothing can be done. Even if your arguments were on merit acceptable, then also nothing can be done. That is the way forward, not by filing writ petition.
No, Lordship, the issue which lies before the single bench it was an issue between the direct recruiting bodies. In case of direct recruiting bodies, that principle is applicable. I agree. In view of the judgment passed in that Uttaranjan Forest Rangers case, that is acceptable.
Understanding one thing, even if the division bench judgment is wrong, I have to follow it. So whether it is right or wrong is not something I can go into in this case. That judgment says seniority should be given to them above you. That will be maintained here also.
No, Lordship. The issue which was involved in the writ petition, that is an issue between the direct recruiting bodies.
Maybe, but the division bench has given a finding which is affecting you.
No, division bench appealed the direction passed by the order passed by the single bench. In case of seniority between the direct recruiting bodies, I also agree that is a correct position. But the issue which is involved in the present writ cases,
I will deal with it. Yes, which judgment you want to show?
Yes, Lordship. Lordship, I'm relying on 1998, volume 5 ACC. Lordship, here also subsequent judgment passed by the Honorable Supreme Court, laying down the principle that in case of direct recruit of the same selection, seniority has to remain on the basis of merit.
If it is appointment is done on the same date, all these judgments,
Lordship,
you have missed out on that.
Lordship,
You came in 6 months later.
Lordship, in this case, Lordship, before I read the relevant portion, the issue here is Here was first selection. Your Worship, in the first selection was for filling up 200 posts of Monsif. Your Worship, the breakup was 152 for general category and 48 posts was reserved for EC/ST candidates. Out of 48 posts reserved for EC/ST candidates, only 15 candidates could qualify. So the Bihar Public Service Commission forwarded only 15 names and they were appointed between March to May 1975. Another advertisement was issued on 14/10/1977 for filling up 152 posts of Monsif, and selected candidates were appointed between May to November 1976. Worship, the 33 posts reserved for EC/ST candidate in the first selection remained vacant, and there was shortage of Monsif. Therefore, state government reserved those 33 posts in the list of 33 candidates were prepared from the merit list of general category of the first selection, and they were appointed between June to September 1976. And these 33 candidates were given seniority against the selected and appointed of the first selection. Worship, in this case, worship, the facts which is mentioned at para 2 to 6 is very relevant, worship.
Yes, you want to refer to which para?
Worship, kindly allow me to refer to para 2 to 6. The fact is very relevant in this case.
Para 36.
No, 2 to 6. 2 to 6.
Yes,
Worship, may I read para 2 to 6?
yes.
On 3/4/1973, the BBC issued advertisement for 200 posts of Monsifs for the 15th examination under the 1955 rules. The breakup of 200 posts was 152 posts for general category and 48 posts were reserved for EC/ST. The BBC conducted the written examination sometime in December 1973. On 26/8/1974, the High Court of Patna conveyed its approval to the proposal of the BBC to fix qualifying marks at 40% for general category candidates and 30% for EC/ST candidates. Those who were qualified in the written list in terms of Rule 19 of 1955 were called for waiver voice in August to September 1974. At the conclusion of these formalities, a common select list based on merit was prepared. Although 48 posts were reserved for EC/ST candidate, but only 15 from the EC/ST candidate could qualify. Thus, the BBAC forwarded a list of 158 candidates to the Bihar government for appointment as Monsif under the 1955 rules, of which 143 candidates belong to general category and 15 to the EC/ST. Those 158 candidates came to be appointed between March 1975 and 22/5/1975 as Monsif under the 1955 rules. While this process was going on 14/10/1974, another advertisement under the 1972 rule was issued by the BBAC for appointment of 152 Monsif to fill in additional temporary posts of Monsif created by the Bihar government. After holding the written examination in waiver voice, merit list of 152 candidates was sent by BBC to the government of Bihar, which appointed them under the 1974 rules between 23/5/1975 and 17/11/1976, initially for a period of 6 months, but the said period was extended thereafter till their confirmation on 22/. Between 14/6/1975 and 4/7/1975, additional 9 candidates as per the merit list under the 1954 came to be appointed, taking the total number of appointment to 167 candidates, comprising of 152 candidates of general category and 115 candidates of EC/ST category. Resultantly, familiar is important. Resultantly, 33 posts of EC/ST candidates remained vacant for one of qualified candidates. Here was acute shortage of bond seat, and since the candidate from the EC/ST candidates were not available in the merit list prepared under the 1955 rules, the state government sometime in June 1976 reserved those 33 posts. In view of this decision, a list of 33 candidates from the merit list prepared under the 1955 rules, received the earlier first selection, was forwarded to the government, and accordingly, between 17/6/1976 and 1/9/1976, those 33 candidates came to be appointed as Monsif. However, one of them died later on. Respondents 3 to 34 are appointees falling in this category. Those 32 candidates were confirmed on 9/3/1983 with effect from the date they were appointed. Those 33 candidates were given the seniority, this is very important. Those 32 candidates were given the seniority over the appellants who were recruited under the 1974 rules and were in fact appointed earlier to them. Naturally, this determination of industry seniority between 32 candidates appointed under the 1955 rules in the appellant appointed under the 1977 rules was sought to be challenged by the appellant in writ petition number by writ petition under Article 26 of the Constitution of India in the Patna High Court. Those were two sets of writ petitions. One, the appellant writ petitioner who were selected and appointed under the 1974 rules. Number two, the EC/ST candidates who were selected and appointed under the 1955 rules. It is a common premise that respondent 3 to 34 were in fact appointed later in point of time than those appellant. At this stage, it needs to be stated that those 32 respondents were placed above the EC/ST candidate in the merit list prepared under the 1955 rules. Procedural. The controversy as regards the seniority started when the Monsif appointed from 15 judicial examination under the 1955 rules were confirmed by notification dated 9/3/1983 with effect from the different dates in the year 1997 and 1978, whereas the Monsif appointed under the 1974 rules were confirmed by government notification dated 22/11/1985 with effect from 1/9/1980, which give advantage to those 32 respondents. Similarly, the Monsif appointed in the subsequent 3 pages, that is 16, 17, and 18 judicial services examination, were also made senior to the Monsif appointed under the 1974 rules. It would be appropriate at this stage to refer to the litigation started in 1985 at the behest of the appellant in CWC number 16216 of 1985, wherein a part of Rule 9 of 1972 rules was challenged. This rule says that an absorption says that on absorption, a Monsif appointed under this rule will not be entitled to recount the period of his service as temporary Monsif for the purpose of his seniority. Challenge to this part of the rule was sustained by the High Court on being unjust and arbitrary, and consequently, a direction was issued by the Patna High Court that seniority of the appointees under the 1974 rules be effects in accordance with law, ignoring the struck down part of Rule 9, Para 4. The Monsif appointed under the 1972 rules, including some of the appellants, claims seniority from the actual date of their appointment, that is 23/3/1975, and requested that he be placed above the present respondent 3 to 34. Against the decision rendered by the Patna High Court in CWCG number 621 of 16 of 1985. Some of the Monsif appointed pursuant to the 15, 16, 17, and 18 pages, apprehending that their seniority might be affected, moved this court by filing 3 special leave petitions, civil number so-and-so, so-and-so, and so-and-so, and the same were dismissed in the following terms. The special leave petitions are dismissed. We shall make it clear, and in fact, it was also considered by the Council for Respondent 126 that the candidates who were selected as a result of the 15th examination and whose appointment was delayed on account of medical examination and police verification of antecedents should be given seniority on the basis of their rank in the merit list in that examination. Anyone appointed subsequent to 23/5/1976 on account of there being no vacancy will rank in seniority according to line of service from the date of actual appointment. Paragraph 5, Lordship. The petitioner in special leave petition number so and so filed a review petition for clarification of this order, but the same was rejected. The order reads as under. We have gone through the review petition and other connected papers. We do not find any merits in the review petition, which is accordingly dismissed. On this backdrop, pleadings of the parties to the present proceedings may now be summarized. According to the appellant, he were appointed in 1975-76, earlier in point of time to respondent number 3 to 34, and therefore, those respondents could not have been placed above them in the seniority list. Such a course was illegal, unconstitutional, and violative of Article 14 and 16 of the Constitution. The decision of the Patna High Court in CWCG number so and so, on the order passed by this court while dismissing special leave petition number so and so, must be treated conclusive and binding upon the respondents. And in view thereof, the respondent cannot claim the seniority over them. The appellant pleaded that the respondents projected an incorrect picture before the Supreme Court that the appointment of some of the Monsif of 15 judicial examination were delayed on account of the medical reports in police verification. None of the respondents belong to this category, but on the contrary, they were appointed as Monsif against the post reserved for SC/ST. The state government had no power to reserve those 33 posts without following the due procedure. Those 33 posts must be deemed to have remained vacant, and against those vacancies, the appellant came to be appointed. Thus, there existed no vacancy, and therefore, respondents 3 to 34 could not claim that they were appointed against such vacant posts. The appellant, having been appointed earlier, he must be treated senior to respondent 3 to 34. Length of service would be the only proper criteria for fixing the seniority, and any deviation herefrom would be violative of Article 14 and 16 of the Constitution. Paragraph 6. The other seat of appellant in civil appeal number so and so belongs to EC/ST group. They were appointed as Monsif on the basis of the merit list of 15 Bihar judicial examination held under the 1955 rules. They pleaded that since they were appointed against the reserve post earlier to respondents 3 to 34, although they were placed higher in the merit list, they could not legitimately claim seniority over them. The seniority must be determined on the basis of actual date of appointment and not retrospective effect. The order dated 14/6/1985 of the Standing Committee of the High Court was illegal in as much as those respondents were made senior to them on the erroneous assumption that those 33 reserved for EC/ST was reserved, but ignoring that no due procedure was followed by the government of Bihar. May I allow to read para 11 also? This is also 11. Para 7, 8, and 9 speaks about the reservation of posts.
So what is the finding? Come to it.
Yes, Lordship. Lordship, the findings at para 24 and 25. Let me read para 24. For the foregoing conclusion, we are of the view that respondents 3 to 34, who were appointed to the vacancies of 15 examination under the 1955 rules, will have to be given seniority over the appellant and civil number so and so. although he came to be appointed later than 23/5/1975, but against 33 vacancies which were then existing, to which those applicants had no right. Paragraph 25. Coming to civil appeal number so and so, filed by two applicants who belong to the reserved category, were selected in the 15th examination under the 1955 rules and were appointed between March 1975 and 22/5/1975. Admittedly, ye were below respondent 3 to 34 in the merit list. As stated earlier, the merit list of the selected candidates forwarded by the BBC was required to be adhered to, and there could be no change in the merit list. Consequently, those appellants cannot claim seniority over respondent number 3 to 24. The claim of the appellant is therefore without any merit. Lordship is a similar suggested facts. Those respondents, they were appointed later after the 2 pages of the selected candidates were appointed, but on the basis of merit. Their seniority were protected. Lordship. This is the on this judgment I made like. And Lordship, in the subsequent judgment also, is a 2007 one. It's a short judgment only. 2007 1 ACC 405. Lordship, here also is a case of delay in submission of the joining report. But the merit list has to be adhered to. That is the findings of the apex commission.
Which para you want to
Lordship,
deny?
I'm relying on para 7 only. This is a reference of an earlier judgment, which is passed in 1994. This court in Chairman Budi Gramya Bank versus Ananda Chandra Das held as follows. Lordship, got it? This appeal arises from the judgment of the High Court of Orissa in OGC number so cadet swings. The respondent and others were selected by direct recruitment as manager of rural bank. His rank was number 9 in the merit list. He was directed to be given seniority on the basis of the date of his reporting to duty. It is reported that the first respondent is dead. The only question in this case is that what shall be the ranking among the direct recruits? This question is very, this query is very important. Is it the date on which he joined duty, or according to the ranking given by the selection board? On comparative evaluation, the respective merits of the candidates for direct recruitment, the board has prepared the merit list on the basis of the rankings secured at the time of.
Yes.
Please, Your Lordship, Lordship has rightly pointed out that the seniority of a person has to be counted from the date he is born into the cadre. Lordship,
Where is the rules?
there is no rule. There is no
I'll
rule.
fault the rules, Lordship. I'm sorry.
For forest ranger, there is no rule.
There is no rule.
There is no rule.
There is no recruitment rule.
No.
Lordship, on last occasion, this writ petition was heard by our retired Justice Serdo. During that time, I placed the rules of Nagaland Public Service Commission recruitment rules of 2008. Lordship,
No, not about the rules. For the forest ranger, there is no rules.
Lordship, for the forest rangers, there's a rule. Lordship, it will be in the record.
Where is the rule? 2008? No.
Lordship, it will be in the record. Oh, it will be in the record. Last occasion, when Justice Serdo heard the matter, I placed the rules in the regulation.
This is the one you are, this is the, just have a look.
Lordship, no.
Lordship, here to one regulation of Nagaland Public Service Commission.
Show it to her. Show it to her. Give it to her.
Seniority for the meeting list.
Seniority, you come to go.
Lordship, Rule 20 says, the seniority of the members of the service recruited under Rule 5.1 should be determined on the basis of the NPSC result and performance of training in the Forest College Institute in the ratio of 50-50. But here in our case, Your Lordship, he did not qualify initially. If the general category did not resign, he could not have been appointed. So, Your Lordship, he was appointed 10 months later than the private respondents. So his seniority has to be counted from the date he is born into the cadre. Then, Lordship, it is very clear here also, he has not challenged this order notification. Lordship, page 44 of the writ petition.
Yes, he
Lordship.
has not challenged which notification?
Page 44 of the writ petition, page 44. Lordship, may come to page 44.
Yes.
This is the notification dated 29 October 2012. In the interest of public service, the governor of Nagaland is pleased to count the past service rendered by Sri Mahmoud, forest ranger. Who
So
served
that is another thing.
Yes.
He is not asking for benefit of his seniority in the previous appointment.
Lordship. But
His-
if we are to count as
Just a
Lordship,
minute, his only case is this,
Mm.
that regardless of whether I was appointed initially
yes,
or after 10 months,
Lordship,
because my appointment is against a general
Yes,
category
Lordship,
post,
yes,
and I have scored higher marks than the reserve
yes,
category.
yes, Lordship,
So I must get
Senior.
seniority.
Yes,
That is his case.
yes,
Correct.
yes,
And to drive home that point,
Mm.
he has relied upon two judgments.
yes, Lordship,
One of it,
Mm.
the essence it says
Mm.
that since the government did not follow the process of derecognition
Mm.
or dereservation,
Mm.
hence, although these posts were dereserved,
Mm.
against which the private respondents 3 to 33 were accommodated.
Mm.
Hence, yet
Mm.
it was not, it cannot be their legitimate claim
Mm.
because they could not have been appointed
Mm.
against those vacancies which were not existent. So even though these people were appointed later,
Mm.
yet because the appointments were not against legitimate vacancies,
Mm.
so they cannot claim seniority.
Mm.
This judgment has further been, this issue has been actually dealt with in the case of Rafiquddin
Mm.
versus State of Bihar. There it is said that even if you are appointed earlier,
Mm.
if your appointment is not against legitimate vacancy, you cannot claim seniority over
Lordship.
people coming in later.
yes,
But that is not the case here.
Mm.
He is not saying that the private respondents were not appointed through a legitimate process or
Yes.
against legitimate
true,
vacancy.
true,
So therefore, we'll have to see whether this judgment would have anything to do.
okay,
The next judgment he has relied upon here, the seniority was given to a person below in the list only because he joined earlier. So that is obviously wrong. The Supreme Court says it can't be done.
Yes.
So these two decisions prima facie do not apply in the facts of this
Yes,
case.
true, exactly.
As you said, this appointment of the writ petitioner is in a way fortuitous because had the other person not
Yes.
resigned, he was
He
in the
would
merit
not have
list, he
been
would not have.
appointed. Okay.
But forget all these things. Single judge and division bench says on length of service, you have to determine seniority.
No, no, Lordship. The single judge says that a person's seniority should be counted from the date he is born into the cadre.
That's right.
Lordship. That's all. Yes. So he has not been born into the cadre. Now, when
And
he
that
asked
judgment has been upheld by the
the
division bench.
division bench, Lordship.
So now this court cannot do anything.
Lordship. Exactly.
Even if he had a case on merit, he should have filed a review or sort a challenge.
So, Your Lordship, the petitioner does not have a case. Lordship. So it should be dismissed.
What is your argument? Can you give the name of the parties, councils?
My lord, I'm for the respondents number of private respondents, my lord.
Numbers?
4, 5, and 6, my lord. Here, my lord. My case is that 4 posts were advertised. Out of the 4 posts, 2 posts were reserved for 50% post was reserved for forestry graduates. That is the respondent number 5 and 6. 4 posts were advertised, my lord, out of which 50% was reserved for forestry graduates. And then against that vacancy, the petitioner, respondent number 5 and 6 were recommended and appointed. And then out of the 50%, that is for general category. Out of the remaining 50%, the respondent number 4 was appointed against backward reservation.
Against?
Backward reservation. The respondent number 4 belongs to backward tribe. So there's a reservation for the backward tribe also. And against the general category, one Shuri that Shuri was appointed. Against his resignation, the petitioner was appointed. That also after about a lapse of 10 months. And then by the time the petitioner was appointed, the private respondents, they were already in service. And while the private respondents were serving, the petitioner was also serving as a jailer, assistant jailer. Only after the resignation of that Dohan Curie, the petitioner was appointed. And the petitioner was emphasizing much on the statement at page number 70, wherein he has relied that in the previous litigation, in the petition, the petitioners who are the present respondents, they have not challenged or raised the issue regarding the seniority of the petitioner. Why? Because that litigation, that petition was regarding the promotees and the direct recruits, claiming seniority of each other. And then in the present case, the issue is regarding the seniority, injustice seniority within direct recruits. Why it was not raised at that point of time? Because the petitioner herein was also one of the direct recruitee, though he was appointed from a waiting list. So that if his seniority was raised, then it will amount to mixed prayer or multiple prayer, and then technically the petition would have not been mentioned. Only after the tentative seniority was issued, since his name was placed above us, we have submitted a representation saying that we should be placed at cell number 25th, and then
yes,
my lord, the representations at page number 51, my lord. Against
those I've seen. You make your submission on legal point. What do you have to say?
Yes. So, my lord, the private respondents here, they were appointed against reserve quota, against a legitimate reserve quota.
Yes.
And then they were appointed much ahead of the petitioner. So when the private respondents were appointed, he was not even in the cadre.
All right, so born in the cadre. That's it.
Yes.
Anything else you want to add? Don't repeat what has been argued.
Yes, my lord.
Anything else you want to add?
My lord, I will just,
Any new point you want to add? Don't
No,
repeat. Huh?
that is the whole issue. And then I will just rely on some judgment, my lord,
No, for what point?
regarding seniority, my lord.
No, that the earlier judgments have been, we are not going into that. That's all.
Lordship, I mean, allow 5 minutes just to
Yes.
prove about the legitimacy of my appointment, Lordship. If the post is governed by the service rule. Lordship, we
No,
kindly-
that argument, don't make it, because we
No, no,
not
no.
even touch it.
No,
Have you challenged their appointment?
no, Lordship, regarding, since I was appointed from a waiting list, the validity of the waiting list. Lordship, I just want to show that.
Validity, who is raising? They are not questioning the validity of the waiting list.
No, if I'm appointed within the validity period, then only by legitimate, right?
Legitimacy is not the question here. Neither are they questioning legitimacy of your appointment, nor are you questioning legitimacy of their appointment. So unnecessarily don't go here and there. This is the problem. This is why these litigations are happening. People go a little here, little there, little there. The main point, everybody loses. You will not get any relief here because you did not file a review against the division bench order. That is only thing you should have done.
No, Lordship, I'm repeating
We'll
it.
deal with it, challenge it.
Lordship, I'm repeating again. The issue involving the writ petition
Even
was-
then, you ask, you consult somebody who's conversant with service rules. You should have. Even now, if you want to withdraw and challenge, then I can give you, but otherwise.
No, Lordship, I'm repeating again. The issue involving the earlier writ petition was issue between the direct recruit in.
Okay, we'll
direct
deal
recruit
with
in
it.
Bombuti.
I will deal with it in the order.
It was a direct recruit in Bombuti. The present issue is between the direct recruit of the same selection. The law is totally different.
All right. So what do you want to say?
Lordship, under the rules, under this rule 6, rule 6 about the validity of the waiting list, Lordship.
The rule?
Rule 6, Lordship.
Yes.
Lordship, we come to rule 6, clause C. And here's subclause 3, subclause 3. Candidate appointment from the waiting list can be done by the appointing authority only in view of. Lordship, Lordship got it, rule subclause 3. Again, subclause 1.3, Lordship. Resigns after joining the post before expiry of 1 year from the time the rules were declared.
Yes.
I was appointed against a resignation vacancy.
You already are. Yes.
Yes, that's all, Lordship.
All right. So heard so-and-so, so-and-so, so-and-so for the writ petitioner, Ms. so-and-so for the state respondent numbers 1, 2, and 3. Mr. So-and-so has appeared for respondent numbers 4, 5, and 6. Arguments concluded, judgment reserved. See, this service matter is like arithmetic. You have to have complete clarity, right? Otherwise, nothing can be done. There has to be complete clarity. You cannot tinker with these things. I understand your point. You are saying that in the earlier round, their projection was something else. Whatever is the projection, but the judgment is something else. You cannot say that, okay, so I don't mind. Now I will start it again.
Lordship,
That
my
is not
continuous
permissible under the
Lordship,
law.
the judgment passed in the earlier writ petition. That is not applicable in my case. Since the law was on the different
All right, we'll deal with it.
Yes, Lordship.
We'll deal with it. Yes. Yes. Next matter. Yes. The item last item. Yes, please.
Well, if this matter can be accommodated on Thursday, because
What is this matter about?
What I'm challenging the appointment of the primary sponsor on the ground that the appointment is against the constitutional scheme. Can you accommodate on Thursday?
Then you do it next week. Thursday, final hearing, I have to deliver a judgment also. On the prayer of learned counsel for both sides, this case for hearing again in the next week. Give this. Give the presence of both sides, Mr. So-and-so for the. He will just give their names. So-and-so for the. Yes, all right, that's all.